Okay, well, welcome everybody to our monthly webinar. And this month we're going to be talking about Capital Raising 101 Legal Essentials for Startups. Before we get into the content for today, for those who don't know, I'm Alex. I am the co founder of Sprintlaw. Sprintlaw is an online law firm really designed to make legal services accessible for startups and small businesses. Unlike traditional lawyers, we don't charge by the hour. Everything we do is fixed fee. And we cover all the different areas of law from helping you set up your business, e-commerce, terms and conditions, IP protection, consumer law, contracts, employment, data and privacy, and of course, as we'll be talking about today, assistance with legals around getting finance or capital raising. We have an optional membership. About 90% of our clients sign up to it, and it's a really great way to get access to our software platform where you can make your own free legal documents. There's an e-signatures tool in there. There's credits to spend on legal services when you need them. And we've recently released a legal AI tool, which is pretty cool. And you can use to get instant answers to questions. There's a voice mode as well, which you can chat to. And you can upload docs and have them reviewed by the AI as well. So for those that are not signed up, I would encourage you to consider checking it out. There is a free tier as well, so you can give it a trial. A bit more about us. We've been around for about 8 years. We have a bit over 7,000 clients. We're in Australia, the UK, and New Zealand. We ourselves have raised many rounds of capital, so we know what it's like to go from the early days of being a startup to sort of scaling up. Lots of industry awards and lots of happy customers. So again, if you're not a client, we are a great choice for those that need legal help. And if you are gripped by an urge to get some legal assistance, off the back of this webinar, we'll drop a link in the chat. Anyone who's here can get a free consult and 10% off any capital raising services that you may need if you just mentioned that you attended this webinar. So let's get into the educational content for today. We'll be basically doing a 101 on capital raising for those of you that are about to capital raise, or if you're just thinking about it for the future. We're going to be covering sort of what to do before a raise. How do you set up for investment? Make sure you got the right kind of sort of business structure. We'll then be going through the main types of raises. We'll dive in a bit more detail into equity raises when you're selling a little bit of the company to investors in exchange for funding. We'll talk a lot about safes and convertible notes, which are increasingly becoming, particularly for startup companies, one of the most dominant forms of capital raising that we see. We'll then touch on some regulatory requirements for anyone who's raising capital, and briefly touch on some of the other documents that may come up if you go down a route other than equity or convertible raising. So that's the agenda. As I'm going through, do feel free to drop questions. We will leave a little bit of time at the end, but I don't mind taking questions kind of as we go through. I think it helps kind of add a bit of color to whatever I'm talking about. So there's a Q&A feature in Zoom. You can pop it open and drop your questions in there, and I'll keep an eye on that as I go through. So let's talk about setting up for investment. So before you, for your organization, go out and start thinking about asking people to put money into your business for whatever purpose you may need it for, you want to make sure you got your house in order. And what we do see for a lot of our clients is, they're running their business, particularly if you're a startup company in your early days, you're doing a lot of things yourself. You might be using legal templates that you've found on the internet for your main contracts. You may have sort of orally agreed all kinds of equity arrangements with your staff. You might have quickly set up a company yourself. You may not have been able to afford or gotten proper legal advice. And, a lot of these things create all kinds of risks, and you want to make sure that everything's sort of tight before you go speaking to investors, because the last thing you want is to sort of like cut a deal with someone, have investment committed, and then they sort of look underneath the hood of your business and say, hey, this thing is a pigsty. There's all kinds of legal risks, and these people, I don't know if I'm going to trust them with my funds. So a trigger point for a lot of our clients to get on top of their legals is contemplating raising capital. And I won't go through all of these areas in detail. We've had other sessions on them, but the sorts of things you want to be thinking about in general is just thinking about the overall legal health of your business. Have you got the right business structure, which we'll talk more about in a moment? Have you got proper contracts in place with your suppliers, with your customers? Is all of your employment law compliance sorted? Have you got proper employment contracts in place? Is your IP protected? Do you own your brand name? Do you own your software code if you're a technology company? Do you own the intangible assets that are really critical to the value of your business? Have you signed documentation making sure that you own them? Are you complying with privacy laws and all those sorts of things? So I would encourage everyone to just do a general stock take of your legal health. And these are, I think, the key areas for startup companies to be thinking about: customers, suppliers, employees, IP, privacy, regulations, these sorts of things. Just get all the documentation in place, and then you're going to kind of clean your house and be ready for investment. But right in the middle, we have the business setup. I think the business structure is one of the key things you want to make sure you get right before you raise investment. And most people thinking of raising investment will already have a company structure. If you don't have a company structure, you're set up as a sole trader or a partnership, it's very difficult to raise investment, because a lot of the way that, at least with equity capital, a lot of the way that investment's raised is by essentially selling off a piece of your company in exchange for investment in the business. And if you have a sole trader structure, you don't really have a company. It's just you doing business, or a partnership is just a couple of people working together as individuals. It's difficult to sell off a piece of those things, and that's one of the reasons that a company structure is generally for serious businesses the right structure to have. So most people know that. Most people would have a company structure set up. If you don't, again, I would suggest you get that sorted before thinking about raising investment. But beyond just the basic fact that a company structure is pretty much a requirement for raising capital, you do see companies use more sophisticated structures or restructure just before a capital raise to have more sophisticated structures to facilitate investment. So many people will have a single company structure. They'll have just set up a company. Maybe there's a couple of founders in the business. The founders would potentially own a percentage of the company, 50% if there's two, maybe it's split into thirds. The founders would often also be the directors of the company, the people who can bind the company for certain decisions. And that's often how you'll see a company set up in its early days. Now, that's fine. That's a fairly standard structure. But it's quite common to consider setting up a dual company structure, or as we have on the right, a trust structure, in preparation for a capital raise. And just to explain what these things are, oftentimes a startup company will have valuable intellectual property, and pretty soon, if it raises investment, it will have a large amount of cash. Now, if you're just running through a single company structure, you have this one kind of entity that's out there doing business, employing people, signing contracts, entering into leases, doing whatever else it is that the company does. And that same company also has all of the kind of family jewels. It has the important intellectual property. It has the cash in its bank account. And if something goes wrong with a client, an employee, a supplier, and a litigation ensues, someone decides to sue the company, everything's at risk. All the cash in the bank's at risk, all the IP is potentially at risk, and it can be business ending. And in startups, mistakes happen in the early days. Even if you think of what happened to you, we see many of our startup clients have issues. Maybe they thought they owned the brand, but they get sued by someone else who has a similar brand name. Maybe there's a mistake that's made in the early days with a customer. Mistakes happen. If a mistake does happen, ideally you don't want it to be business ending. But if you have everything in the company, in one single company, all of your eggs are in one basket. So most lawyers would recommend considering splitting your structure into a dual company structure, which we have on the middle of the screen. You have a holding company. That holding company is kind of your safety deposit box. It's got all of your valuable intellectual property. It's got the cash that you raised, or at least a lot of the cash that you raised. And then your operating company is the one going out, doing business, signing contracts, employing people, et cetera, et cetera. Now, if something happens down at the operating company level, someone decides to sue your organization, they may be able to come after the operating capital that's in the operating company's bank account, but the key assets of your business, the IP, that might be very valuable if you've created a software application or some other invention, or if it's just cash that you have but a significant amount, that in many cases will not be at risk, because you've essentially set up these two individual companies. Another advantage of the holding company structure is if you want to expand into different business lines or different countries, setting up the two levels enables you to also do that more easily. And again, each time you set up another entity, you're essentially siloing the risk associated with whatever business is being run through that entity to that entity. So to just bring that to life a little more, to give you an example of Sprintlaw, when Sprintlaw started, we were a single company structure. around the time we went to raise our first round of capital, we split into a holding operating company structure. We set up Sprintlaw Group Pty Ltd and then Sprintlaw Pty Ltd. Again, for the purposes I mentioned earlier, because we wanted to keep our key assets sort of safe. Then we expanded into the UK and we set up another entity, which was another operating company called Sprintlaw UK Limited, a UK company. And with that structure, essentially, if something goes wrong in the UK business, the Australian business's assets and the holding company's assets are not, in most cases, at risk because they're separate companies. Similarly, if something goes wrong in the Australian business, it may not affect the UK or the holding company. And in all cases, we kind of have three buckets of risk before something could be business ending. So you can see the advantage. And again, if you're operating in the UK, for example, if that's a plan for people here, if they want to expand internationally, you often do need a local entity. And if you just have a single company structure, you don't really have those two levels needed to create a parent-subsidiary relationship. So again, very common to do this split. There's other reasons. It's not just country expansion. You may have two entities. Maybe you've got a software component and a services component to your business. Maybe you have two brands, two business lines. Maybe you intend to do that in future. Either way, this concept of being able to silo risk into different entities is a powerful argument for sort of splitting them into different buckets. So yes, definitely something to think about for those that are raising investment is restructuring and setting up these dual company structures. Now, on the right, we have the trust structure, which is a more advanced version of the dual company structure. So it still really is the dual company structure at the bottom level. You can see it's still got a holding company, operating company. Up the top, though, there's some stuff going on with the owners of the company. And so this is a common structure that we see founders sort of set up. And again, we've done this at Sprintlaw as well. Rather than the founders owning directly their stake in the holding company, they instead set up personal trusts or sort of intermediary companies. And those companies are the sort of legal people that own their stake in the holding company, which then obviously owns the operating company. So why do you do that? Well, there's a couple of reasons. From a legal perspective, when you set up these companies, one of the key purposes, as I've been mentioning, is to silo your risk. If something goes wrong with an employee or a customer, it's limited to that operating company. It doesn't affect the holding company, and it certainly doesn't affect the founders right up at the top. But if there is a dispute between founders, they're signing their agreements to set up the holding company and become shareholders as individuals. If there's a dispute between the founders or founders and investors, the founders can be personally liable because there's no company in between them and these people. There's only companies between them and their customers. So essentially, one of the key reasons for setting up these trusts is you provide an extra shield of liability as against other founders or investors. And again, you may have your own personal assets, your house, your home, your car, whatever it is, and you don't want that stuff to be put at risk if something goes wrong in the business. And so this trust company, again, puts a shield between you as an individual and risk associated with your business partners or investors. I say in most cases because, of course, if there's criminal activity or fraud committed, some of these protections of a company don't apply. But in most cases, if something goes wrong, the business shuts down, it goes insolvent, it can be advantageous if there's a dispute sort of at this level to have these trusts set up. That's one of the reasons. The other reason is that there are certain tax advantages to having a trust structure when dividends are paid out of the company, or if the company is eventually sold. Not something as lawyers that we really talk about, more a question for sort of accountants and tax advisors, but it is very common for people to choose the trust structure as well, because it's sort of has these tax advantages. And whether or not it has tax advantages sort of depends on your personal circumstances, but just sort of empirically, the vast majority of founders that get advice sort of end up with this structure on the right. So if you're considering raising sort of equity capital, this is probably the structure that you may want to aim for. I should say it's expensive because you have to set up, in this case, 1, 2, 3, 4 companies. There's tax returns for all of them. There's registration costs. When I say expensive, if you do it with Sprintlaw, we're probably talking $3,000, $4,000 to get it set up, and then 1,000-ish a year for your or a bit more for your annual renewals and tax filings. So that's kind of what I mean. If you're raising millions of investment or whatever it is, then it's really absolutely a worthwhile investment. But many people, certainly when you're running small businesses and not intending to raise millions of investment, will stick with the single company structure until they can kind of afford the restructure. But if you can afford it, certainly this is the one that we see most. So hopefully that makes sense. But yes, very commonly we see this trust structure used, and certainly at Sprintlaw, that's kind of where we've ended up as well. So that's on the structuring, and again, a lot of people do that prior to the raise. We do see some people, go out, raise investment, shake hands on deals, and then at the last minute attempt to rush the restructuring. I would suggest, if you can, to get this done early. It can take time, even though the setups can be pretty quick for the entities. If you've been around for a little while, even if it's just a year, you probably got bank accounts set up in a certain way. You may have all your subscriptions under a certain entity, and you might have to cancel your bank account and open a new one and change all sorts of administrative things to restructure, which can take time. And if you are wanting to close an investment deal and you're having to restructure at the last minute, it can be very stressful. So I would suggest getting this done early, really in anticipation for a raise. And even if you don't raise, it's still a good structure to have, albeit it does cost that little bit more. So once you've got your structure in order, once you've got your legal house in order with the cleanup of your agreements, we can now think about what types of fundraising exist and may be suitable for your organization. So we have on screen for startup companies in Australia, the three most common ways that sort of startup private companies raise investment. The first is straight equity. They will basically take X dollars from an investor and give the investor Y percentage of their company straight away. So this is probably the form of investment most people are familiar with. Sell off a little bit of the company for some money and then use that money to sort of grow the company. We have then the convertible and the safe note, which are similar sorts of documents. And these are a little different to straight equity. I like to describe them as sort of pre-sale tickets to the equity show, if you will. So what you often will do is, prior to actually giving away a percentage of your company, you might take a little bit of funding in advance of that and say, hey, I want the funding now. I'm not going to give you the equity right away because I still need to, get set up, work out what the company's worth, and potentially get some more investors on before I'm ready to give away a percentage of the company. But when I do give away a percentage of the company, you as the convertible note holder or safe note holder will get a discount on the price everybody else pays to get their percentage. So you'll get a better deal if you give me the money in advance of the equity round. So the key component of these documents is the startup company gets the money now. It doesn't actually give away the percentage of the company right away, but instead it gives the investors a discount on the price that other people will pay later to get that percentage. So in most cases, you're going to be doing your convertible or safe note in advance of doing a straight equity round. So you might, let's say you raise a safe note and convertible note in 2025. You might raise, $300,000 in 2025 with the idea that maybe next year you're going to raise $1 million in straight equity. And the people that put $300,000 in 2025 and 2026 will get $330,000 worth of equity in the business, i.e. they get a little bit extra. So that's kind of how the discount works and what these things are. And again, they're very attractive, which we'll talk about in a bit more detail how they work for startup companies, because they're a lot easier and faster and quicker than doing all the administration of issuing the equity. Now, the only difference between a safe note and convertible note is this concept of interest. Convertible notes typically have interest on them, so the investor will put in the money now. Not only do they get a discount, but it's kind of a loan in the meantime, and so they can get paid back on their investment with interest until such time as this equity event happens, and then they get the discount on conversion. Many convertible notes don't actually require the repayment to be made in money to the investor. They just stack up to make the investment bigger. So they end up with a discount plus interest as well. So doubly extra on their initial investment. The safe note is a simple form of convertible note, which was invented, I think, in 2016 or 2017 over in the US by Y Combinator, a famous startup accelerator. And they just sort of wanted to do something like a convertible note, but make it a lot simpler and just have kind of more basic terms. And also, due to US securities law, if there was going to be interest paid, it would have been considered a debt instrument and have some tax consequences. So they invented this thing, simple agreement for future equity, which is what SAFE stands for, safe note. And it became kind of globally popular, even though in Australia we don't have that US law around the sort of debt. It's just become a popular way to raise. So if you hear convertible safe, they're pretty similar. It's just that the interest isn't there, and oftentimes, safe notes would have a bigger discount than convertible notes to reflect the fact that there's no interest, but they're very, very similar in nature, if that makes sense. So those are sort of the main types of raises that we see for startups. Now, of course, there's other ways that your startup can get funding that it might need. One is through government grants. There's plenty of grant programs for very early stage companies. There's MVP grants that are done sort of at a state level. There's industry-specific grants that exist. There's export grants and R&D grants for those developing sort of innovative technologies or science. They sometimes come with conditions attached, but can be a great way to get funding. There's debt, of course. Instead of selling off a piece of your company or doing the safe or convertible notes, you can just get a loan. Now, of course, loans are very difficult to get for early stage companies. Often the big banks want security of some sort, or they want to see some profitability or some trading history. You may be able to get a loan if you're willing to take it out in your own name, but of course then you put yourself at risk and your own assets, but some people do that. You may be able to get private loans from friends or angel investors. There's also a bunch of, in recent years, venture debt lenders that have emerged who will provide unsecured debt specifically for startup companies at pretty high interest rates, but oftentimes they'll take a little bit of equity too and help you raise an equity round. So we are seeing that become an increasingly common form of funding, and we're also seeing a new form of lending called R&D lending emerge, where again, if it's been around for a little while, but if you're getting an R&D grant, but you got to wait to get the money, you could often get loans in advance of that. So quite a few debt options. Certainly in the last few years, I've seen a lot more startups use debt. It was not really available. 5-10 years ago, it was very difficult to get loans if you weren't a bigger company, but something to look at. We have crowdfunding and equity crowdfunding. Crowdfunding, of course, people will be familiar with launching a product and promising people rewards in exchange for funding that project. Kickstarter is, I think, the most well-known site that does that. So only suitable for some sorts of businesses, but another way to get funding. And again, another new way of funding that's emerging in Australia, really in the last 5 years since some laws were passed, allowing this, is a form of fundraising called equity crowdfunding, where you can essentially do one of these straight equity rounds online on a platform. And instead of getting 5-6 high net worth or institutional fund investors to invest in your company, you can raise from a large pool of individuals who put in a little bit of money, and then you have tons of small investors in the business. And there's advantages and disadvantages to that, but again, we are seeing that become a popular form of fundraising, and the process is a little different. Because there's legal requirements around what you have to say and do when you're raising from through an equity crowdfunding platform. So we will spend most of the session talking about these types of raises and issues associated with them, but it is worth being aware that there are these other types. And again, I'll briefly touch on the documentation a little bit later on. So let's talk about an equity raise. So how does an equity raise work? If you want to go out and raise funding, you want to sell off a little bit of the business to an investor, how do we get from A to B, from thinking about the process to actually having all the documents signed and the money in your bank? Well, There's a few stages to go through. Now, of course, I'll focus on the legal stuff, but prior to getting to the legal stuff, you'll often see startup companies put together their pitch deck, their presentation to say why their company is amazing. They'll work out the story to tell investors, hey, you're going to take a percentage of the company and for this much money, and our goal is to grow it by X, Y, Z over the next X years, and that percentage of yours will be worth a lot more than what you're putting in, and here's why. So that story needs to be told inside the pitch deck or business plan, or however you want to present your story. Typically, there'll be a period of discussion with investors, and oftentimes where you end up is having this document called a term sheet signed. So a term sheet is typically not actually like a binding legal document. It's just a tool used to prepare for formalizing an investment. It's usually a couple of pages, 2 to 3 pages, and it's just almost a kind of table or bullet point list of the key aspects of a deal that you might agree with an investor. So a term sheet will typically say, this is the name of our company. We're going to be offering up to 10% to investors for $1 million investment because we think we're worth $10 million right now. And as an investor, you will, own this percentage of the company. You'll have these rights once you become an investor. We'll send you these kind of updates. You'll have this say over these certain types of decisions. Please let us know by this date if you're interested. Then the investor will ideally sign the term sheet. So that's kind of how the process goes. Sometimes if you work with, if you're looking at sort of discussions with venture capital firms or institutional investors, they'll be the ones to give you the term sheet. So, you'll meet with them, you'll give them the pitch, but they'll have their own terms that they like to see, and they'll adjust it based on your business. So they'll say, okay, well, we think you're worth about this much money. So we think, we want 10% for this much, and we want these rights, and, we want this say in these kinds of decisions. And this is kind of how we are going to propose to do it. It depends on the circumstance, whether the founder or the founders propose the term sheet or the investor proposes the term sheet. It's oftentimes a founder will end up with a better deal if they go out with their proposed terms rather than letting someone else dictate the terms to them. But equally, if as a founder you're able to get offers from 5 or 6 different institutional funds, you can sort of play them against each other and get a better deal. But the term sheet is where a lot of the negotiation happens, and a lot of the negotiation in the term sheet, because this document again is not legally binding, is around what percentage are we giving away? So effectively, what is the company worth? How much are we going to give away for what amount of money? So there's a lot of conversations around that, and that's often negotiated. And then control rights. What rights will the investor have? On one extreme, will they have absolutely no rights? They're just putting in money and the founders are free to do what they want. Or on the other extreme, are they quite involved in the organization? Are they going to be on the board of directors? Are a bunch of decisions going to need their approval? Do they have to tick off on founder salaries if the founder leaves quickly? And we'll go through some of those rights in a moment. What will happen? So control and sort of valuation are the two things that really are discussed in these term sheet documents. And again, they're not legal usually, because these kinds of discussions are often what lawyers would call commercial discussions around how the investment deal is going to work. And when they're signed, it's almost like a handshake agreement. Okay, we agree in principle on the key things. Now let's hand it over to the lawyers to do the proper legal documentation. So once you've got a term sheet signed, then the lawyers are going to help put together all of the documents that are needed in the equity raise to sort of make it happen. Now there's really 2 or 3 key documents to be aware of. The first is the shareholders agreement, and then we've got the constitution, which is oftentimes not that important because a lot of the details included in the shareholders agreement, and then we've got the subscription agreement. So those are kind of the key documents, the ones we have here. There's other documents, employment agreements, service agreements, IP deeds that may be needed, which we'll come to in a second. But let's just go through these key ones in a bit of detail first. So the first document to be aware of is this subscription agreement. So this is the document that says, I, the investor, am putting in this much money and you're going to give me this many shares. It's a pretty straightforward document. It says the amount that they're putting in and the amount of shares that they're going to get. it will have a section saying um, uh, of what we call company warranties. So of things that the investor has relied on to make the investment. So the investment will say, "Hey, I'm giving you this money on the basis that you didn't lie to me. Your forecasts were reasonably true. You provided me with all relevant information. The company is not currently being sued. There's no hidden skeletons in the closet, et cetera, et cetera." So there'll often be a list of things that the investor is kind of relying on for their investment. And if those things turn out not to be true, the investor may have rights against the company. But in general, a lot of this document is about the transaction, how much money is going in, and what sort of amount of shares or effective percentage of the company are they going to get. So that's the subscription agreement. Then we have the shareholders agreement and constitution. So these documents deal with what happens after the money's come in and what rights will the investor have as compared to the founders on an ongoing basis as now a shareholder or a part of the organization. So this will sort of set out which decisions require the approval of investors and which decisions that the founders may be able to make themselves, processes to be followed if the organization wants to be sold, what approvals are needed by investors, if the organization wants to raise more funding in the future, can they just go out and do it, or do they need to ask investors first, et cetera, et cetera. So all of those kinds of things are covered in the shareholders agreement. So whereas the subscription agreement just covers the transaction, the shareholders agreement covers the relationship on an ongoing basis. The constitution also does that. Constitutions, I mean, it used to be the case that we didn't have these things called shareholders agreements. We had these constitutions, which are also sort of documents that bind all shareholders and directors. But constitutions are kind of regulated documents that require a certain amount of approvals to change things, and they're not as flexible. So it's become fairly common practice in a lot of private companies to have this separate document called a shareholders agreement, which is a bit more flexible. And so the constitution these days often is a template document that just says, this is how a board meeting will be run and this is how votes are taken. But the actual rights of people in terms of what percentage approvals are needed, what kinds of decisions are needed, what happens in all those circumstances are contained in the shareholders agreement. So they're similar purpose documents, but the shareholders agreement is really the one which we see a lot of the detail in most equity raises be contained in. So just to recap, we got the term sheet, which is the kind of first thing that's signed, the almost the handshake agreement. Then we got the subscription agreement, which is the transaction document. I, the investor, will give X dollars for this amount. And then we've got the ongoing documents, shareholders agreement, constitution, which cover the ongoing relationships and the rights of the investors. So that's the kind of core of the raise. Now, it may be the case that, I mentioned earlier, you want to get your house in order prior to the raise. If your house isn't in order, oftentimes the investors will ask you to clean it up before they put the money in. And so sometimes we see in the term sheet things in there that say the founders must sign a document called an IP assignment deed, proving to us that everything they've ever created is owned by the company and that they're not going to later on run away and start another company. It may be as well that it's agreed with the investors what salary the founders are going to get. And so employment agreements have to be set up confirming that around the same time that the investment comes in. It might be that the investors want to see an employee share option plan in place. So the founders and the company are agreeing to give a little bit to motivate other staff. And again, so that might be a condition of investment. So there can be other legal documents that sort of come into existence in association with the raise. But in general, the key documents are sort of these ones up the top. So that's the equity raise. Now, you can see it's a little involved. There's a term sheet. There's documents to be signed, potentially several documents to be assigned, and it's a little bit of work. Of course, it's done all the time, and lawyers who do this stuff know how to do it. So it's all doable. But oftentimes we see people want to raise money a little more quickly using these other types of fundraising instruments, the safe and convertible notes that I mentioned earlier. So if you're raising through a safe and convertible note, the process is a lot simpler and a lot quicker. And again, you're not avoiding having to do all this work, because in most cases, these things are like a pre-sale ticket to the show. Of course, you have to actually have the show if you're selling pre-sale tickets. But if you need the money now and you want to do the admin later, it can be an advantage for using these documents. Another big advantage for using these documents is because all you're promising, as I mentioned earlier, is this discounted rate. It saves you as an organization trying to value your company, which can be difficult to do. When you're a startup company, working out what the valuation is, what percentage you're going to give away to an investor for what amount of money, it's difficult to work out. It's not like you can go to an accountant and say, value my business in the same way a cafe or a restaurant may be valued. That might have trading history and profit over a few years. Oftentimes, you've got a business plan, a deck, and a vision, but you have no money yet, or you've got a little bit of money yet that doesn't reflect where this thing could go. So it can be difficult to value the company. It becomes easier over time as the company becomes more developed. But these safe and convertible notes can be a way to get funding in while delaying the question as to what the company is actually worth. All it says is, we don't know what we're worth yet, but you, the investor, will get a discounted rate once we work it out and do the full equity round. So those are a couple of reasons. It's faster. We delay the valuation question. And that's why we see a lot of these instruments being used. And I would say, and again, it's shifted since we started Sprintlaw in 2017. From what we've seen, over half of startups' first fundraise, we see using like a safe note or a convertible note. And more commonly, it is a safe note now. So it's a very, very common way to raise your first funding round for the reasons that I mentioned. It's faster, it's easier, and you delay the question of valuation. So definitely something to consider if you're thinking of fundraising. So inside these documents, the process is simpler. We're not going to have necessarily a term sheet and all of the shareholders agreements, subscription agreements, because no one's getting the rights yet. All we're selling is the pre-sale ticket. So a safe note as a legal document is, a 5 to 10 page document, and it really has between 2 to 4 key terms in it. The rest of it is mostly templated. The first is this discount rate, which I mentioned. What is the early bird discount that the investor's getting? The second is this concept of a valuation cap. And again, not all safe notes have a valuation cap, but to explain what it is. So in addition to getting an early bird discount, an investor might say, well, I'm investing in you early. We don't know what you're worth, but I'm going to take let's say 20% discount on what you are worth. But then the investor might say, but what happens if after I put in the money, you blow up, you become worth tons and tons of money? I'm taking the risk now. I got in before you blew up. You became really, really valuable. Why is it that I only get 20%? Because if you're now went from being worth $1 million to 100 million, and I get 20% discount on 100 million, I got in when you were probably worth more like 1 million. So oftentimes you'll put what's called a valuation cap, and you'll say, okay, you get a 20% discount on our next funding round. But if our next funding round values us at a much higher amount than we ever expected, we won't rely on the discount. We'll just cap out the amount that you convert at. So for example, you might have a safe note with a 20% discount and a 10 million valuation cap. If the startup then signs the agreement, takes the money with the safe investor, the startup then raises at 8 million, then the investor gets the discount of 20%. But if at the next round, the founder raises at, let's say, 25 million, well, now we're above this cap of 10 million. So instead of getting a 20% discount on 25 million, the investor just converts as if the company was worth 10 million, if that makes sense. So it's kind of an upper cap. It's good for the investor, the cap. It's not as good for the company, but it's fairly common. Discounts are in about 95% of safe notes that we see. Valuation caps are probably in about 75% of safe notes we see. So it's very common to have these terms. So got the discount, what you get as an early bird, and then a cap. If the company is worth a lot, well, we just flatten it to whatever that cap is. Then you got the trigger. So what actually is the equity show? Like, is it when because obviously, if we say you're buying early bird tickets to the equity show and you get a discount on the value of the company at that time, we don't want the equity show to be when the company raises $20,000 later this year, because the founder could just then invest $20,000 themselves, trigger it, and cause all the safe notes to convert. So oftentimes there's a definition of this is your pre-sale discount, and it will convert when the company raises at least X million dollars or X $100,000 of investment from third-party sophisticated investors. And this is again another protection for the investor to say, I want my discount, and I want my discount to be on a rate that's determined by some serious investors, so I know that my discount is pegged to a real value of the business. So this is another term where you've got to work out what is the trigger, and what amount of money are we going to say has to be put in to trigger the safe and convertible note. So that's kind of in most of the documents. And finally, we have the concept of interest and maturity date. Now interest is in the convertible notes, rarely in the safe notes, and maturity dates are reasonably uncommon in the safe and convertible notes, but probably becoming a little more common in the last couple of years. But I would say, maybe 25 to 30% of these safe and convertible notes have a maturity date, based on what we've seen from sort of early stage startup capital raising, certainly at the seed stage. So what is a maturity date? Well, what happens if the show never comes? What happens if you've raised a ton of money from investors saying you get a discount on the rate of our future investment round up to this cap? And we think we're going to do it next year, but it just so happens that after that the company becomes profitable and starts doing very well and never needs to raise any funding again. What happens to the safe and convertible note holders? Well, they don't want to necessarily be stuck sitting there with these convertible notes. They're not yet part owners of the company. They've been promised a discount on a thing that never happened. They don't really have any rights when you're a safe or convertible note holder. You're still waiting for this moment when you become a shareholder as an investor. So, it might be the case that the investor asks that, okay, if nothing happens in the next 2 years, everything will automatically convert at some value, often the valuation cap. Our stake, if you haven't raised any money in 2 years, you've got to give us the shares as if you were valued at the valuation cap. So that's kind of what a maturity date is. It has a hard stop on these pre-sale tickets and forces the show to happen, if you will, if nothing has happened by a certain date. We often see these set at 2 to 3 years. Now, the reason it's uncommon, because you might think, well, that sounds quite sensible. Why isn't that always there? The reason it's uncommon is because in most cases, when we see funding rounds happen, it's pretty obvious that there's going to have to be a funding round for the company, because they won't have a clear path to profitability. So oftentimes, investors just take the risk that the funding round will happen, but it is a risk, and that's why the maturity date concept exists. And I would say savvier investors will ask for this, and maybe one of the reasons that it's not there is because investors don't really know about it as a concept. And Sprintlaw, for example, we've raised I think 3 rounds using safe notes, and then we've obviously had equity rounds as well in our funding journey. We have savvy investors, some of whom are lawyers, and so all of them, we had a val cap, a discount, and a maturity date. So certainly it is done, but for our clients, we often see the maturity date sort of not in there. So hopefully that makes sense in terms of what these documents are. Again, I like my analogy of thinking of them as the pre-sale tickets. And as I said, they're quite common and a really simple and easy way to do your first funding round. So do consider it if you're thinking about that. Now, just to talk a little bit about the rights of investors. So, once your investors get their shares, become shareholders, part owners of the company, whether it's through an equity raise or whether they started as a safe holder and then later on converted. I mentioned earlier, they will typically get some rights in relation to your company. Prior to having the investors, if it's just the founders, if this is your first funding round, you as the founders control the company. You're probably used to making all the decisions. You are the board, you are the owners, and you sort of decide what you think is best for the company. But when investors put money in and get their stake in the business, they often want to make sure their investment's protected. And while they may trust you to run the organization, if you're going off the rails or going in the wrong direction, they may want a little control to nudge you back in the right direction. Or maybe they'll want a lot of control to nudge you back in the right direction. Now, if they're just the safe holders, one of the risks with being a safe or convertible note holder is that you don't yet own any stake of the company. So they don't really have a say in most cases. But once you issue them the shares, they actually have a legal stake in your company, actually own a bit of your company. So they have legal rights. Now, the strength of those legal rights turns around what was put in the shareholders agreement, what was agreed in the term sheet. But the common things that investors will ask for is, first of all, board appointment rights. They'll ask that, they have a seat on the board, and that will mean that, and you may not even run board meetings if you're a very early stage company. It will mean that you need to meet at X frequency, monthly, quarterly, whatever is agreed, and provide updates to the investor and anyone else who's on the board as to what's happening in the organization. And depending on what's in the shareholders agreement, you may need to get certain approvals from this board in order to do things that you want to do in your company. Maybe it's increase the founders' salaries. Maybe it's acquire another business. Maybe it's raise investment. Maybe it's take out a loan of some sort. Oftentimes, the board allows day-to-day decisions to be made by the people running the business. It doesn't want to approve every little thing. But for significant decisions, it can't just be made in the day-to-day of the business. If there's a board, it often will need the approval of the board. And investors may ask for them to appoint their own nominated person to, or people, sometimes more than one person, to sit on the board and at least have a say in those decisions, and potentially sometimes veto decisions they don't agree with, i.e. you'll need their approval. So it's a pretty significant power for investors to be on the board. But if they're putting in a lot of money, you can sort of see why they might ask for that. And again, it's often negotiated in terms of what power that person has, who is going to be appointed and how all that process works, and whether they can outvote other people on the board. So that's one big area where we see sort of control come in from an investor. Founder vesting is another thing, which investors will say, okay, look, I'm going to give you X dollar, I'll give you $1 million for your business. But, if one of the founders who currently owns 30% of the company or whatever it is leaves the next day, there's no way they get to keep their 30% because we just put $1 million in this business. So they'll often ask for founders to agree to a vesting schedule, which will say something like, you must stay as a founder in the organization for at least 4 years to keep your full stake. For each year you stay, you can lock in 25% of your stake, but if you leave within a year of us putting in the money, you lose everything. If you leave after a year, you only keep 25%, and so on and so forth. So again, quite common for investors to ask that the founders agree to give up their stake in the company if they leave early. And again, this can be emotional for founders, particularly if they've been running the business for years before the investment came in. They may say, well, what do you mean I'm going to lose all of it? What about all the work I did before? So this can be negotiated in terms of how much is kept by the founders and how much they would lose, but certainly a common concept that investors may ask for. They might ask for restraints. They'll say founders agree, they might leave the company. Not only might they lose a bit of their stake, they agree not to go and start a competitive business and steal all of the learnings they took and all the learnings they got with our money and start like the same business again, but cut us out of the picture. So you often see restraints in the shareholders agreement. Investors will want reports, updates on numbers. So they'll ask for, let's say monthly or quarterly P&L. We discussed warranties already. They'll want promises that there's no skeletons in the closet before money comes in, and potentially be able to take back some of their money if something turns out later to not be true. Then we have these last two concepts that are a little more technical but worth understanding. Often investors, particularly venture capital investors, will ask for a term called a liquidity preference. And what this means is an investor will often put money in the business, let's say $1 million, expecting that million will turn into 2, 3, 4, 10, 20 million, hopefully for them, when they put in the funding. Now, what happens if the business doesn't do as well as expected and is sold for less than what they thought the company was worth, even at the time of investment? If the investor put in $1 million and they only get back $500K because the business fails or is acquired by somebody at a sooner pace, the investor's not very happy because they've lost half of their investment. So a liquidity preference says, we, the investor, yes, we're going to have 5-10% of your company. But if the day that you sell your company, if the fact that we only have 5 or 10% means that we make a loss, we don't just get 5 or 10% back. We get a refund of what we invested at least. We get, in that case, what we call a one-time liquidity preference. We get the money we invested back instead of just our percentage. And that protects the investor from the case where the company ends up being sold for less than what they invested in. So it's great for the investors. It's not as good for the company, but you can see why the investor is going to ask for it. Some aggressive funding rounds, we see investors ask for a 2 times liquidity preference or a 3 times liquidity preference, where they say, hey, I'm happy to have 5 or 10% of the company, but if I put in $1 million and I make less than $3 million back, I get $3 million rather than my 5 or 10%. Bit unusual, but we do see that sometimes. And again, much better for the investor because they've locked in a 300% return or whatever it is on their investment if they can get you to agree to that. So, often you'll read headlines and you'll see, startup raises at $80 million at a 200 million valuation or whatever it is, and you'll think, oh wow, these people are worth so much. This company's worth so much. They've got so much capital, and that can look good on paper. But often those investments will have a liquidity preference, which means that while the company may have a lot of funding, if the company does not deliver on its promise to be worth more than what they were worth at the time of the raise, the founders themselves may not get a cent, even if the company ends up selling for a reasonably high price, because the investors are going to ask for their money back, if that makes sense. So it's a pretty significant term and worth getting your head around. And again, it's fairly common, certainly in venture capital investments. And finally, you see anti-dilution clauses. So investors who are putting money into a business obviously want it to grow as much as possible. If it's the case that the company raises funding and everyone thinks it's worth 10 million at the time, but then 2 years later it's not doing as well as people expected, and the company needs to raise more funding at a lower valuation, now it's only worth 8 million, the early investors could be a little annoyed because the company went in the wrong direction. They didn't get as much bang for their buck. Anti-dilution clauses allow them, usually through a kind of slightly complex formula that I won't go into, allow them to get a little more equity for free if the valuation drops at the next funding round, if that makes sense. So again, it stops them being diluted by people that got a better deal than them in the case that the company goes worse than expected. So again, the key terms are often the value of the company and the percentage that the investor's getting, but these other terms can have a pretty significant impact. How much control is being given to these investors? What happens if the founders want to leave? What happens if the company goes in a different direction to what the pitch deck said? There's different ways investors can end up with a bit of a better deal. So worth being aware of what you're signing, and certainly getting your head around particularly this liquidity preference and anti-dilution concept. So that covers, I think, the equity stuff, the safe and convertible note stuff. Now, one thing to mention, many startups tick this box anyway, but it is a legal requirement. If you are a small company that is raising investment, you need to make sure that the Corporation Act allows you to do it without issuing a prospectus or a big disclosure document. People may be aware when a big company listed on the Australian Stock Exchange or any other stock exchange wants to raise investment, it has to put out a big key risk document to let everybody know what the risks are with the investment and what's at stake, and it needs to tick a whole bunch of boxes. Smaller companies, it's too big a burden to put on them. So the Corporation Act allows people to raise these safe rounds, these equity rounds and convertible rounds, without doing all the work of getting a big disclosure document signed, but only if certain criteria are met. The common exceptions are if the investor is what's called a sophisticated investor, i.e. their net worth is above a certain amount or their salary is above a certain amount. That's number one. So if you're raising from wealthy individuals, that's fine. If you're raising from not wealthy individuals, you might have to rely on a different exception. Another common one is you're raising less than $2 million from 20 people in any 12-month period. If it's what's called a small scale raise, you can raise from anyone, your friends, your family, or other people. And then there's also a kind of friends and family rule that specifically says, particularly for people that are related to you, there can be an exception as well to allow them to invest in the business. But you cannot just go out, and I unfortunately see a lot of startup companies do this, put your pitch deck on LinkedIn, run some ads and say, we're raising funding, invest now. This kind of like public offer is not allowed to be done by private companies. It has to be done on a individual relationship basis under one of these exceptions, or you risk breaching the law. So don't think you can go out and market your raise. The one exception to that is, of course, if you do equity crowdfunding, which I touched on earlier. That whole system was set up to allow some limited promotion for startup companies to raise investments. So It can be done through those platforms, but there's a bunch more boxes that have to be ticked, including some kind of risk documents put together. But in general, for your private startup raises, it kind of has to be these personal offers where you meet the investor, you make sure that they're either sophisticated or you're raising less than 2 mil, and the deal is done privately, if you will. So very very much worth being aware of. And again, I think a lot of companies aren't aware of that, and I see people posting on LinkedIn asking for funding, which is really actually a breach of these laws and could lead to fines or penalties. So do be careful with that. So just to quickly touch on, again, the other funding types, you don't have to raise through equity, you don't have to raise through SAFEs and convertible notes, and there are legal documents at play if you use one of the other forms. If you get a grant, there's often a grant agreement the government will send to you with a bunch of conditions attached. If you do debt financing, whether it's through venture debt or a private loan, there's usually a document called a loan agreement, which sets out what you have to pay, what the interest is, and what happens if you don't pay, what the events of default are. So again, if you're raising through debt, definitely get a contract in place or have the contract reviewed if it's given to you by a lender, because there can be some nasty consequences if you don't pay on time. Crowdfunding, if you just do the sort of old school crowdfunding, you just want to make sure you know what the terms and conditions are on the platform and that you're not saying things that you can't. And of course, equity crowdfunding, I touched on a couple of times. Equity crowdfunding is similar in effect to the equity raise, but because you're raising from so many different people, it's actually uncommon if you do equity crowdfunding to have a shareholders agreement, because often you'll have 100 small scale investors through the platform. So there's a kind of, and again, it's still, the legals are still developing around how we're going to do this in general in Australia, but what we're seeing is just something called what we call a CSF constitution. So a big constitution is the place where it says what rights all of the individuals that invest through equity crowdfunding have. So again, the process is a little different if you're doing that, but the platforms like Virtual or On Market or Venture Crowd can guide you through the process. So that is all the content I was going to cover. If people want to ask questions in the Q&A, do feel free to drop them. We have a couple of minutes left. Otherwise, I hope people found this useful. We'll upload a recording, I think, onto YouTube, and we do these every month. So for people who are interested in learning about particular topics, definitely let us know. And otherwise, I'd encourage people to sign up to our free membership if you're not already a member. And you can also stay on top of things that way. Looks like we haven't got any questions, so we might drop off. But thanks, everyone, and I hope you all found this useful. Actually, Alex has just sent through. We've got a couple of questions. Let me go through them. Alex has just asked, can shareholders agreements be rewritten? Yes, they can. It requires the approval of all shareholders. So oftentimes, founders will put in place a shareholders agreement on day one of the business or pretty close to day one of the business. And then when the investors come in, the investors say, hey, your shareholders agreement is all good and well, but it doesn't have any rights for us in there. So oftentimes the shareholders agreement is rewritten around the time of investment. Then, the first investors come in. Later on, we may see other investors come in and not like that shareholders agreement, so it'll get renegotiated again. Every time it's renegotiated and rewritten, it needs the approval of everyone to sign it. Now, one sort of tip or trick here, which I often suggest to early stage companies, is if you're planning to raise investment, some people think, I'm not going to do my shareholders agreement because the investors are going to ask for stuff anyway. Why would I pay lawyers twice? The shareholders agreements aren't that expensive. And again, I've seen this time and time again. Founders that have a shareholders agreement in place prior to a funding round often get a better deal and have to give up less rights, because they can say to the investors, look, this is our existing shareholders agreement. So we're happy to make some changes, but don't make us rewrite this whole thing. It's quite a powerful negotiating tool. So I would suggest, again, for founders out there who don't have shareholders agreements, get one in place, even if you might have to change it later and have it rewritten, because it does improve your negotiating position. And you become more sophisticated in terms of understanding the issues at play just by going through the process of putting one together. Dennis has asked the question, what defines a sophisticated investor? I will do the best to answer that off the top of my head, but apologies if I'm slightly off. And again, you can probably just Google that or and get an answer on it. But I believe it's if you're the individual's annual income is above 250K a year gross, or if the other test is if their assets exceed 10 million Australian dollars in value. I might have got those numbers slightly wrong, but it's something like that. And there's another similar sort of definition for fund investors who have an Australian financial services license. They're also allowed to invest under a similar sophisticated investor type exception. So again, that gives you a sense. But if you just kind of look on ASIC's website and type in sophisticated investor meaning, it'll have the exact answer to that. Alex has asked, as you go through fundraising rounds, based on a shareholders agreement may not suit the future. I think what you're saying is yes, that's sort of what I was saying earlier. It's likely that your shareholders agreement will slightly change over time, although you'd be surprised how often I see an early shareholders agreement make it through a lot of funding rounds, which ends up being good for the founders. But yes, oftentimes, particularly as bigger investors come in, they don't like what's there. They want more control, and things get changed. And that's just part of the process. It's very much a living document. Jaja's asked, can dual company and trust structure be switched easily? Not that easily. And this is why we recommend doing this stuff early on. There can be, if you do it when you're very small, like you wait 3 months, you have no revenue or whatever, it's not that hard to change. But there's at least 2 problems with restructuring too late in your journey. One is to move from a single to a dual company structure. You have to actually sell, in most cases, sell the shares from the individuals to the holding company. And there can be a CGT event. So tax is paid on the restructure if the company is worth something. And again, same thing can happen with trusts. If the shares of the founders are worth a lot of money and you're moving from an individual holding to a trust holding, tax can be payable, which could be a significant amount if the company is worth a lot. So a lot of founders tell me, oh man, I wish I did the trust structure from day one because now it's too expensive for me to do it. And then there's the administration of moving all your bank accounts and all that kind of stuff. So, I mean, look, it can be done and people do it after a little while, but the sooner the better it would be my recommendation. Jazz asked, if the company's not registered in Australia, can they raise capital? Certainly they can. A lot of what I talked about today was the Australian legal position around capital raising. It is possible for an Australian company to raise funding from international investors as long as they comply with a lot of the rules that we discussed. And if large amounts are invested, there are some like foreign ownership rules and you need to get some government approvals. But in general, if you're raising in the UK or the US or some other country or in Asia and your company's registered there, the laws of that country will apply. And, it'll be in principle similar to what I discussed, but they'll have their own conventions and their own laws, and so you'd have to get local legal advice if you were going to do that. Robert said, we have a founder dual trust dual company arrangement. However, all developments have been incurred by the operating business. Will that cause complications? Not necessarily. What you would usually do, though, is you would have what's called an intercompany. And again, I don't know how your dual company was set up, but you have an intercompany IP assignment agreement. So what happens is this operating company, incurs all of the costs, but there's a kind of a contract that's signed between these two entities, which should have been set up when you did your dual company. If it isn't, maybe get in touch with us and we can help you put it together. And what it says is, hey, any IP owned by the operating company will, hereby in the past and in the future be transferred up to the operating company. So all the IP kind of moves in the background to the holding company. So it's fine if the operating company pays the developer, then the money comes, then the IP will sort of go to the operating company for a split second and then be passed up under this document that I just mentioned to the holding company, and then it's kind of protected. So so it is fine for the cost to be incurred, but you just got to make sure you got that IP document in the background. And when I say it's fine, I'm talking from a legal perspective. If there's grants and things, I'm not totally sure how that works in terms of, if the grant's with the holding company, but you paid through the operating company, you'd have to ask the government in that case. But what you've described is very common. The operating business usually incurs the costs, and they just have this document in the background that moves the IP. Some good questions. Alex has asked, if attracting overseas investors in an early stage round, are there many other complications? It's not that complicated. It's very, very common. It's normally more complicated for the overseas investor than it is for you as the company, because they may have, less tax benefits by investing in you. A lot, they may not be familiar with, a lot of Australian companies struggle to raise US investment with an Australian head co just because the investors in the US say, I don't understand your country and I don't want to invest in that country, so you better move to the US. And certainly you see some of that in the UK. UK investors they got really great tax breaks for startup investments. So the investors there can be reticent to invest, but that's more a commercial point. In legal terms, there's not too many extra loopholes to jump through. You're allowed to have foreign investors in your company. It's just we've got FIRB, the Foreign Investment Review Board. If a significant amount of money is coming in or properties involved, there are approvals that you need to get for like national security purposes and so on. But for small scale investments, often the FIRB laws are very low threshold or not a big deal. So it's not. I wouldn't worry about that too much. I'd worry more about convincing the investors to sort of invest. Sam said, can we have the cost setting up trust structure third option? I loosely sketched that out before, but it's it's about $1,000 a company, so it depends on how many founders you have. Probably a little less if you do them all together. So 1, 2, 3, 4K is roughly what the setup cost would be for this structure. But then there's also annual renewals, which is about $250 per company per year, and then tax returns and administration as well. So there are flow-on costs, but the setup is around that mark. At least our prices are. You can go and ask. Accountants also can set up this stuff as well. It doesn't have to be lawyers, so you can get other quotes as well. Awesome, a great bunch of questions there. Thanks everyone. Well, I think we're about a bit over time, but thanks for sticking around, and yeah, I look forward to potentially working with all of you, and otherwise we'll see you again next month for the next webinar. I'll see you later.